Good afternoon, everyone. I think that the stream has started, so I shall crack on. Thank you for joining this seminar titled Courtcraft for Social Workers. It's a really warm day, and we do appreciate you giving up your lunch hour to join. My name is Aaqib. I'm a barrister at Aspire Barristers. I specialise predominantly in public family law, although we do also do private family law, and I also do some court of protection work. And one of the areas that we do have a lot of input and engagement with is working for and with local authorities in care proceedings, which is where we see the bulk of our engagement with social workers. So hopefully both Francesca and I can lend our experience and assist those attending today.
Hello, I'm Francesca. My background is very similar to Aaqib's. I also specialise in family law, particularly private law, but also quite a lot of public law. I both represent parents and local authorities, and of course when representing local authorities, come into contact with social workers very frequently. As Aaqib has said, hopefully today will be useful for you all. There's not an option with this platform to ask questions, so Aaqib and I have put our email addresses on the screen now. We'll just give you a couple of minutes to note those down. If anyone has any questions during the presentation, Aaqib and I will check our emails at the end and answer anything anyone wishes us to look at. So I'll just give you a moment to note those down, and then we'll start the presentation. So the topics today can be seen on screen now. We're going to begin by going over an overview of the family court system and also of care proceedings, just to look at some of the different types of law that you should be aware of when doing social work in a court setting. We'll also look at court etiquette and best practice for when attending court, top tips and things that we find are practical and helpful for both social workers and also the lawyer representing the local authority at any case management or other types of hearings. And then we'll finish by looking at written evidence. So that involves both initial social work evidence templates and final social work evidence templates. And then also how to prepare for giving evidence in court orally, both examination in chief, so answering questions from your lawyer, and also by looking at cross-examination, so that's when you're questioned by the opponent. So hopefully that will give what will most likely be a whistle-stop tour today of the things that you should be aware of when doing social work in a court setting.
So in terms of the family court then, it sits under the civil court. So family proceedings are, strictly speaking, civil proceedings, but there is a set rule book called the Family Procedure Rules, which govern family courts. And the way that family courts work is that the family court essentially sits anywhere. So strictly speaking and technically speaking, it's the same court, but it sits in, say, Sheffield or Leeds or Bradford. Of course, that means that there will always be different judges, or most likely there'll be different judges based in different areas. And if, for example, you're in front of magistrates, there are usually two, sometimes three laypersons, so not qualified members of the public, but volunteers who give up their time to essentially sit on the bench, and they're accompanied by a legal advisor. Importantly, there's no jury in family court proceedings, so essentially the judge decides upon issues of, if I can put it, as guilt or liability. So for example, in public law proceedings, you may have a fact find, and the judge is essentially the tribunal of fact. So the judge is the person who deals with what occurred and what didn't occur. And also then the judge will also deal with the welfare aspects. And that's in the absence of any jury, which is clearly different from how things work in the criminal courts.
So one thing to be aware of when considering what kind of judge you're in front of is allocation. This is something that as a social worker you don't need to be overly worried about, because it's not something that will concern you directly, but it's something to be aware of and know about when the word comes up. When a case initially comes to court, you might all be familiar with the gatekeeping process. So when proceedings are issued, they go through there's a gatekeeping order, and usually within that a legal advisor or a judge will decide how the case is going to be allocated. There's several different levels of allocation. Magistrates are the lowest level for the most simple cases. Then it goes up to a district judge, a circuit judge, and high court judge and above. The most common judges to be involved in care proceedings are district judges and circuit judges, although there has been a recent push for magistrates to take on more care work. In terms of who deals with what, this depends on complexity. So, for example, if there's likely to be an expert report, even if that's just a psychological assessment, which tend to be quite commonplace in care proceedings now, those sorts of hearings won't be dealt with by magistrates and are much more likely to go to a district or circuit judge. If there are allegations of serious injuries, non-accidental injuries, or perhaps sexual abuse, then it may be that the case is allocated to a circuit judge, and sometimes even the DFJ, the designated family judge, who is sort of the head judge in each area. So there's a DFJ for Leeds, a DFJ for Sheffield, and so on. And those are the judges who are responsible for making directions for their court area. An example of how this makes things slightly different is that the DFJ in Leeds is Her Honour Judge Hillier, which some of you may be familiar with. One of her preferences is that the local authority file what we call a written opening at the issues resolution hearing rather than a case summary. Those are documents that you may or may not be familiar with, but for the lawyers are quite important different documents. Those are the sorts of decisions that the DFJ makes for their area, and they have directions that only apply to the area in which they are responsible for. If your case is in front of the DFJ, I think you should be on your best behaviour, and just particularly if it's Her Honour Judge Hillier. As if any of you have been in front of her, you will know she's very particular, and rightly so. So as I say, allocation isn't something as a social worker that you need to be worried about, but it's certainly something to be aware of and mindful of, and hopefully that just explains what the word means when it comes up.
So in terms of your involvement as social workers, as I imagine most of the attendees are social workers, but social workers are or could be involved in two types of proceedings: public law proceedings and private law proceedings. And I have had cases where they have started off as private law proceedings, so that's two parents asking the court to decide upon issues in respect of their children or their child, and because of various issues that arise, they then turn into public law proceedings where the local authority gets involved. In terms of private law, it may come as news to you that actually even in private law social workers can be heavily involved, and that's quite often because children are on a child in need plan or perhaps even on a child protection plan, and they are involved within private law disputes between parents, but also because depending on the level of involvement and the types of arrangements which have been made in your local area, you may as social workers be tasked with completing Section 7 reports, which is essentially is a welfare analysis in respect of the children concerned. There are various agreements and arrangements made at local levels as to whether that's something that CAFCAS deals with or whether social workers deal with. But a good rule of thumb is that if social workers are actively involved with these children or this child, then the chances are that it will be your job to complete the Section 7 report. But of course, it's not just a Section 7 report that you may have to complete. The court can direct what's called a Section 37 report, and essentially that's a more robust document that's usually directed when the court is concerned with the welfare of the children, to the extent that public law proceedings or public law orders may be envisaged, and so you as a social worker may need to complete an assessment or a report under Section 37, where you then have to recommend whether you as a local authority will be commencing care proceedings or applying for interim supervision orders and the like. So even if it's just a private law matter, if you're involved, the stakes can be quite high for the parents. And so it's important that you apply and approach private law proceedings with the same rigour that you would public law proceedings.
So the PLO is something that hopefully you're already aware of, but if you're not, then you absolutely should be. This is the public law outline, and it was set out initially in 2014, and it sets out the way that care proceedings should run. There should be 3 hearings in the life of the case, ideally, although most of you, if you've had lots of work as a social worker in court setting, will know that that's not something that happens ever so often. But in principle, there should be an initial case management hearing, an issues resolution hearing, and then a final hearing. There might also be interim contested removal hearings on an urgent basis or on a evidence basis, and there also might be a finding of fact midway through the case, depending on the context of it. The time limit for care proceedings is 26 weeks, and this is a time limit and not an aim. It's something which is flexible if it has to be, but the court has to consider it to be necessary to extend proceedings and can only do so at 8 weeks a time. If you have been in court recently, you might have noticed some of the judges now are a lot more conscious of having it recorded on the order why they've extended proceedings and why there's needed to be delay, because it's something that at the moment the president of the family division is very keen on minimising. It's important to bear this in mind when suggesting timescales for assessments and how you plan ahead. It's also important to be aware of when panels take place, when you're timetabling your assessments, and to make sure that the assessment and the final evidence, for example, can be filed on time and within that 26-week time scale. The different types of panels that you will probably no doubt already be aware of are, of course, panel for adoption. That's called different things in different places. For example, I know in Calderdale it's called SHOPBA. There's also, of course, fostering panel, and particularly with fostering, it's important to check that the DBS checks of any alternative carers have been done and the medical checks have been done well in advance. There have been far too many cases I've been involved in, both for parents and for the local authority, where somebody early on has forgotten to ask for the DBS and medical checks to be done, and it's caused a great deal of delay towards the end of proceedings. That's particularly important in cases where the long-term plan for the children is either one of foster care but with a relative, or a special guardianship assessment. The court won't be impressed if it's these relatively practical and minor issues which haven't been sorted out and therefore cause a lot of delay for the children and those final orders being made. So the 26-week timetable is something to be very aware of, and to remember that whilst previously it perhaps has been a lot more flexible, now that's certainly no longer the case and won't be going forwards. So any extensions need to be absolutely necessary, which they should have been before, but I think things have become a lot more flexible, particularly during a lockdown. So now it needs to be a focus on keeping things on track, and that's important from the very first day that the timetabling is set out.
In terms of the PLO process, then you may have heard that earlier this year there was a relaunch of the PLO process. Essentially, that means that there needs to be a more rigid approach towards how we manage cases within the family court arena. And because, of course, the local authority will be involved at an earlier stage than the court will be, there is an expectation that the local authority, in cases where the children are known, where there are plans in place, and there are long-standing or current, if I can say, issues with the parents, that the local authority will have invested time and energy in completing pre-birth assessments in the case of unborn children, and any pre-proceedings parenting assessments and assessments of family members. What that does is, of course, it front loads a case in terms of the local authority being able to establish its position very early on in terms of what it says are the risks, concerns, and the issues that require further assessment. And it's really important to note here that even though there may have that you may have completed pre-birth assessments and parenting assessments of various people, during proceedings you will then be expected to complete further work with the parents, which will then be used as the document which informs what happens with the children at the end of proceedings. So it's important that even though there may have been assessment and work to be carried out at an earlier stage, that you keep an open mind and approach any further work whilst considering all the available options. And so further down this slide is perhaps something more appropriate for the lawyers involved in these cases, but there's a very strict process which the court is expected to follow. But as Francesca has said, this is a model, but certainly sometimes there are urgent issues which arise. There might be placement breakdowns, for example. There might be applications for experts which weren't foreseen at the first case management hearing. But nonetheless, it's really important that any delay is minimized, because ultimately the delay in proceedings has an impact on the children involved, and that is something that the court is all too keen to emphasize now.
So hopefully the things on this slide will be obvious to most of you watching, and I'm sure the majority of you do all of these things already when you come to court, but it doesn't hurt to have a reminder. Court etiquette for social workers is relatively basic in its requirements, but it's really, really important. The first thing is that you have to be at court on time. There's a direction on every single order which asks that the parties and their representatives arrive at least 1 hour before the time of the hearing is listed, and that includes social workers. It's really important that social workers attend on time, to be able to give instructions and to be able to speak to their lawyer about the hearing and what it's going to entail, so that they can have full instructions when they go into court. Of course, everybody is late sometimes if things go wrong, if transport doesn't come through on time. Those are all things which are completely reasonable, but need to be exceptions to the rule. And certainly if any of those things do happen, then there's an expectation that you get in touch with either your solicitor or your barrister if you have their direct details, and let them know that you're running late. It's not helpful at all, and certainly the judge is not impressed if the professionals are not there on time. They have slightly more lenience when it comes to parents, but it sets the tone if the professionals are all there when they should be. During the hearing, it's important that you pay attention. Again, that might be a relatively basic thing that you would all tend to do anyway, but there are times that I've observed professionals perhaps trying to get on with other things during a hearing because they don't think that the part that we're discussing is necessarily relevant to them, and then they're caught off guard when the judge asks a question. This doesn't happen very often because the majority of the questions will be going directly to your lawyer because they're the person that's there to speak on your behalf. But there might be very niche points that the judge wants to know that the lawyer doesn't have that information to hand immediately, and therefore has to revert to the social worker. For example, if the judge asks when did the parents last attend contact, and the lawyer knows it was at some point last week, but the judge wants to know a specific date, that's something that you as a social worker on the ground will immediately have to hand and can answer the judge and help. But you need to be on the ball and ready to answer those questions if they come up. In terms of dress, it just needs to be smart, casual or smart. You haven't got to come in a three-piece suit, but certainly dark clothing and appropriate clothing for court is really important. Flip-flops, despite the weather, are not appropriate. And certainly, again, that sets the tone if the professional comes in something that's not the right kind of dress. Whilst at court, you need to stay close to your lawyer to provide instructions. There's no harm in saying hello to the parents, introducing yourself to them again if they've not met you before, if they've not met you recently. Hopefully, if they're engaging, they will have done. but on occasion that's important. But for the rest of the time, you need to be with your lawyer so they can take instructions. The parents will have their own representatives, they will be giving their own instructions, and it's important that whilst you're at court, any communication largely goes through the lawyers rather than through directly between the social worker and the parents. You also need to be conscious at court that the discussions between the social worker and the lawyer are private. In lots of courtrooms now, there's very limited conference room space. This means that sometimes there might have to be conversations held on the concourse in a quiet corner somewhere, but the emphasis on that is quiet. It's important that you remember that parents and their representatives might be not too far away because they haven't got anywhere private to sit either, and you don't want them to overhear the instructions that you're giving or the conversations that you're having. It's helpful to just remember that sometimes and be mindful that whilst you feel that what you're saying might not be important, all of the discussions we have are of course confidential, and there shouldn't be an opportunity for other people to be able to overhear, but particularly not parents if we're discussing something that's relatively sensitive and needs to be presented by the lawyer and not the social worker. In terms of practical tips for attending court, the first and most important one is that you need to be prepared. This means checking things in advance and being ready to give instructions. Again, as we've said before, dates are really important for when you can file assessments, and including making sure that any panel dates are factored into that. This might involve speaking to other members of your department. It might involve going to see fostering and asking them when they can file a full connected carers assessment. It might involve speaking to housing about their timescales. And it also might involve speaking to your manager or even higher management if there's issues to be decided, such as funding decisions. All of that work, as far as possible, should be done before we get to court. Some of the court buildings have quite poor signal and poor Wi-Fi, and sometimes getting instructions from somebody else in a different team, they might not be available immediately, and so doing that can be quite difficult. So it's really important that as far as possible you come prepared with all of the information from the other people in the social work team so that you can give full instructions to your lawyer. Importantly, in terms of timescales, is when you're offering a date for an assessment, such as a parenting assessment, do not offer an unrealistic date. Particularly at the first hearing, the judge will want to timetable through. They're not going to be impressed if, for example, you suggest it's going to take 22 weeks to do a parenting assessment, but they will be concerned if you say it's going to take 6 weeks instead of 10 or 12, because it needs to be a piece of work that's done thoroughly, properly, but also completed on time. There's no point suggesting a date which you think everyone will be happy to hear and something that's very quick, if actually realistically you know that it's not going to be possible to do that. For example, have you got 2 weeks of annual leave booked just before you need to complete a parenting assessment? So will it be realistic to do that? Or do you know that there are other things in your diary which are due around the same time? Are you giving evidence in a final hearing the week before and know that you're going to have very little time to be doing paperwork? All of those things are important to consider when offering the dates for assessments, and if it's better to be realistic at the start and explain why you might need a little bit more time than to have to come back to court midway through proceedings to apologise to the court and the parties and say, I'm really sorry, actually I haven't been able to complete it because of X, Y and Z, and it turns out that X, Y and Z were things that you were aware of when offering that date. So that's something just to be aware of. It's wonderful when social workers are helpful and say that they can do things really quickly, but nobody's going to criticise you if you say that you need a bit more time to do what are extremely important assessments for these children. If you're not sure when your lawyer asks you a question, then simply just say so. If it's something that you need to check with your manager, that's absolutely fine. We would much rather that you went and got the information from the person who has it or gets confirmation of any instructions than for you to say something and then later on realise that you should have checked with somebody first, or that you've given an answer that you were guessing about and not something that you were sure of. If you want to go away and check your notes on something, or if you need to go and speak to another professional that's involved, that's absolutely fine. The most important thing is that when your lawyer is speaking to the judge and to the other parties, that they have the correct information. The same applies in court. If your lawyer turns around, asks you a question, and you're unsure of the answer, then you can simply say, I'm unsure, I might need to go away and check that. I might need to speak to somebody else, or could you give me a couple of minutes and I'll tell you in a moment. All of those things are completely reasonable answers, and certainly the judge isn't going to be bothered at all if the social worker is honest and says, I just need to make sure that that's correct. They would much rather that than you give an answer that you're unsure of and then the lawyer has to go on and correct it later and say, actually, that's not the case.
So in terms of your written evidence, as a social worker, you'll need to complete a number of different documents, and there is usually a template document that's used, and that's called a sweat document. But depending on what type of case and what type of statement it is, it might not be precisely that document, but that's usually the format that it takes. And the advice and the pointer set out on this slide really apply irrespective of what stage of proceedings you're at. So this could be the very first statement, or it could be part of the final evidence, or anything in between. The principles set out are the same. And of course, it may come across as being quite obvious. So for example, spell checking your documents. It's a fairly obvious issue, but given that sometimes documents are prepared because of urgent deadlines, etc., it's really important that those type of things are not left behind, and it's really important that the judge read the document, which does come across as being quite considered, quite thoughtful, quite balanced, and also detailed, because as the person or the professional on the ground, you really are at the front line when it comes to knowing what's going on with the family, with the children, and the wider issues in any case. So it's really important that that detail is provided, and that includes who has done what, where has something occurred, when it occurred, how, why, all of these things. And that applies both to when you are writing a statement in respect of welfare issues, but also factual issues. So, for example, you might not have been a social worker, but you might be a family support worker, and you might have been assisting the family when you noticed, for example, a child with bruises. And if you were indeed the first person to notice that, and you are then told by the court, well, you need to file a statement, it's really, really important that you're able to put as much detail in that statement as possible, including the type of things that you don't ordinarily think would be important. So, for example, if you've seen a child with what you suspect are injuries, how did the parents react? Were they presenting in any unusual way? What was the child's presentation? Was the child giving obvious signs of distress? All of these matters are crucial when it comes to a potential fact find, because that will inform the court's picture of exactly what was going on at the time of a child being harmed, for example. So all of these issues and pieces of advice in this PowerPoint slide are really important for you to consider, and it's also really important that you are balanced. I think there is a tendency as a local authority social worker that there is the impression that because we are within the court proceedings, and in a manner they are adversarial proceedings, so the parents might not agree with what you're saying, but nonetheless it's really important to be fair. And in my experience, having a fair and balanced social work statement always impresses judges more than a statement which comes across as being closed-minded or unfair in respect of the parents. And so, depending on what type of proceedings you're involved with, your legal team may remind you of the legal tests and principles which apply. So, for example, if you are making an application for interim removal of these children into foster care, there needs to be a risk of immediate and significant harm. It's a very high threshold to meet, and so you'll need to justify in your statement why you say that part of the test is met. And then there are other such matters, such as the no order principle, which is a principle contained in statute. So it's part of the law in terms of, well, does the court even have to make an order at the end end of proceedings, and that's something that you'll need to address as part of your options. And also looking at the least interventionist order. So, for example, I've had cases where children have been placed with family members at the end of proceedings, but depending on the circumstances of any given case, that has ranged from a special guardianship order all the way to a care order, and you'll need to justify why you say the order that you are seeking is proportionate. And of course, you'll know the test for adoption, which is that nothing else will do, but of course that needs you to look at the wider circumstances of the family and the children as well. So it's really important that you are able to signpost judges in your written evidence as to why you have reached the conclusion that you have reached. And in terms of what goes into your statement, depending on what it addresses, you'll need to ensure that all the information that the court has required is contained in the statement. So there are some statements in which the order, the previous order, specifically states the judge saying, I need information on XYZ issue, and that can be your guideline. But of course, if it's final evidence, you'll need to apply the welfare checklist. And please remember that if it is an application for a placement order, then the Adoption and Children Act applies, and that's got a slightly different welfare checklist, which will need to be applied and looked at when you are looking at all of the options available.
So now we're just going to go through some of the case law that you should be aware of when writing your final evidence. This isn't something that social workers are expected to refer to by name by any means, but it's important to be aware of the relevant legal principles to apply over and above the ones that Aaqib has just outlined. The first case to consider is Re A, a fact-finding hearing, which was from 2011. And this relates primarily to the issue of threshold. Threshold is a document that I'm sure you will have all at some point seen, and essentially sets out the local authority's case against the parents. It's for the local authority to prove on a balance of probabilities the facts upon which it seeks to rely. And if the local authority's case is challenged on some factual point, it must adduce proper evidence to establish what it seeks to prove. Whilst reliance is often placed on material to be found in local authority case records or social work chronologies, which is hearsay, a local authority which is unwilling or unable to produce the witnesses who can speak of such matters firsthand may find itself in great difficulties if a parent not merely puts the matter in issue, but goes into the witness box to deny it. So essentially the key points to take from Re A are that this is essential when considering issuing proceedings at the beginning, which is something that of course your lawyer will advise you of, but it's also something to be aware of when considering points on during interim removal stage. This is something which the parents will heavily rely on when looking at threshold, and will be asking the local authority to have produced all of the relevant evidence. So when writing your statements, whether that's an initial statement or even a final statement, you need to be aware that it is, of course, on the local authority to prove the facts that they are asserting and not for the parents to disprove this. So you always need to be referring back to the evidence that you rely on, and that needs to be first-hand evidence rather than hearsay. To give an example, if you are aware from a family support worker that they saw, for example, a dad leaving a property where mum is living, mum and dad have said that they're not in a relationship, they're not spending any time together because there's a risk associated with that relationship. In your statement, you are more than entitled to say the family support worker told me that she saw dad leaving the property. But importantly, you would then need to have a statement from that family support worker setting out what she saw or he saw and what they can describe of that incident, because that's the first-hand evidence and that's what needs to be relied on when pursuing whatever findings you pursue against the parents. And that's important right at the beginning at the interim stage, because those are often issues which are in dispute and can be absolutely instrumental to the issue of removal and beyond.
So in terms of looking at how to prove a case, the local authority has to establish a link between the facts which have been proven and the harm that you, as a social worker, say that the child is likely to suffer or has suffered. And so that must be based on evidence, and you cannot speculate. And so you must be looking at why you say there are risks associated with certain behaviour. And that can be quite difficult sometimes, even though it might not immediately come across as being challenging. So, for example, have you got a case where one parent is a functioning drug user and is offering care to the child, and with the support of the other parent, if there are two parents involved, then actually that support is good enough. And if that is your honest professional opinion, then you must say so. And so it can be quite tricky, even though there might be issues of harm that you've identified. It does not always translate into that leading to a certain welfare outcome. Those are two very different things. And the point about the local authority not relying upon speculative facts and assertion, yes, as the social workers, you must produce evidence to prove your case, but there are certain issues which that the court can often properly be invited to draw an inference from, and that's something that your lawyers should look at and advise you on, because it does differ from case to case. But for example, if once again drugs are an issue in a case, and one or both parents or whoever's involved has missed a drug test, that in itself may not be enough to speculate that they are indeed taking whatever drugs you say they have been taking. But if combined with their presentation, you have reason to suspect that they may be using drugs again, then that needs to be set out very clearly in your statement, setting out exactly where you've seen them, how they presented, all of that information, which will then lead or allow your lawyer to properly look at, to properly invite the court to draw an inference. So it can be done, but as a local authority social worker, you must be very careful not to ask the court to find something as factual when the evidence just isn't there, because of course further down the line that becomes a point of appeal. And just on this case of REA from 2011, another principle that was noted by the judge in that case was that the court and actually we as a whole must be willing to tolerate diverse and unequal standards of parenting, and that means that you must keep an open mind as to what is good enough parenting, and that will always depend on how the children react to parenting. I've had cases where, for example, a parent has taken children and raised them in rural Scotland, and that's a bit of an unusual case, but indeed the court has been invited to accept that actually for these children that is the norm, and so issues which might be issues elsewhere aren't issues in their current situation. So it can be very nuanced. So please bear in mind that diverse parenting does exist. There's no uniform or one size fits all approach towards what parenting or what good enough parenting looks like. And of course, the parents only have to, or rather you as a local authority social worker need to prove to the court that the parents cannot provide good enough parenting. And that actually isn't a very high bar for the parents to achieve. So you must ensure that your analysis is robust and can respond to that test.
So again, these are just further rules of evidence that you need to be aware of when writing your both initial and final statements and anything in between. In terms of primary versus hearsay evidence, I think we've discussed that briefly. That's the difference between you having witnessed something directly yourself, either you've seen it, heard it, or seen direct evidence of it. For example, again, if we go back to the example of mum and dad in a relationship when they shouldn't be, if you have seen text messages from mum to dad on mum's phone that she's shown you, that would still be primary evidence in respect of you describing what you saw. And hearsay evidence is somebody else telling you that they've seen something, and you then relying on it. So those are very important distinctions to be made. The rules of evidence in the family court are very different from those in the criminal court, if any of you have ever had any involvement with the criminal justice system. There are very strict rules of evidence in crime about what can and cannot be admitted. In family law, the rules are a lot more relaxed. Generally, the rule is that if the evidence being admitted will assist the court in making decisions about the children, then it can go in. So there is quite often a lot of hearsay evidence within the bundle of family law proceedings in care proceedings, and that's not necessarily a bad thing, but it's just important to be aware of the differences between them and the fact that the court will place less weight on hearsay evidence compared to primary evidence because of the way that it's come about. The burden of proof lies with the local authority, so it's on you as social workers within your written evidence to prove that the parents have done something which you allege them to have done, or an issue is an issue that you allege there to be. There's no burden on the parent to prove otherwise. For example, it's for you as the local authority to prove, as Aaqib just outlined, that the parent cannot provide good enough parenting. It's not for the parent to prove that they can provide such parenting. The local authority is the applicant in the case, and so it's on you to provide the evidence and build your case for the court, and not for the parents to do that in response. Very occasionally there is a pseudo burden when the parents are alleging a particular thing happening in contradiction to what the local authority says happened, but that relates mainly to non-accidental injury cases, and the Lancashire County Council case that's on your screen now was one of those. Otherwise, in principle, there is no burden on pseudo burden on the parents or obligation on any of the respondents. The parents do not have to prove their innocence, and that's a really important thing to remember. Again, going back to the example of separated or not separated parents, it's for the local authority to show that those parents are in a relationship or provide the evidence which the court can infer that they are. For example, having seen text messages, professionals having seen one of the parents leave the other's property, or even perhaps sometimes the children saying that mum and dad had been overnight in the same property together. All of those things are helpful evidence to infer that they are in fact in a relationship. It's not for mum and dad to disprove that or suggest otherwise. They may provide other explanations for things that you as a social worker say you have observed, but they haven't got to prove that their version is the truth over yours. And of course, as a reminder, and I'm sure you'll all be aware, the standard of proof in family proceedings is of course just balance of probabilities. So it's very different from crime, where there's a much higher bar. In care proceedings, it's simply 50-50. Can you get over that 51% and convince the judge that in fact on the balance of probabilities the evidence that you're presenting is the correct and the truth? It's not for the parents to provide that. That again is on the local authority. In terms of what to avoid doing in your written evidence, it's essentially to make sure you don't forget to do any of the things that we've just outlined, because those are the do's. But importantly, you should not waffle in your evidence, to use a colloquial term. It's important to be detailed, and it's important to get across the important points for the judge to read and for the parents, and having the detail, as we've outlined, about who saw what, when it was, how a parent reacted, is all essential evidence. What is less essential evidence is repeating information that's in several other documents, because it doesn't help the judge, because they will have read it before, and it actually takes away from the salient points that are in the rest of your document. There's also an impact on some of the parents by waffling in documents. And an example of this is that I represented a mother in care proceedings recently who was perhaps not your average mother in care proceedings. She was very well educated. She was very engaged in proceedings to the point that she read all of the documents and read every single word of them, which was brilliant because she wanted to engage and she was able to engage. But what it meant was that she was reading documents, for example, her positive parenting assessment, which referenced in a lot of detail the reasons why proceedings were issued. Now, it's of course really important for background to be in all of the documents, and that can be brief or detailed depending on the case. But it's important just to consider the context when you're writing these things. So for her, reading a positive parenting assessment, while she's got to acknowledge what's gone before and the reason why we're in proceedings, what she didn't need to read was exact extracts of things that she had said to Dad that the local authority relied upon, which were very upsetting things for her to go back over at a point where she had come a long way from saying those things. And that made her very upset and actually made her feel hostile towards the social worker for having included that. And whilst as her lawyer, of course, I explained that that wasn't the intention, and that unfortunately was how it came across. That's just something to be aware of, that if you know that, for example, parents will read everything in detail, just think about whether or not everything needs to be in that document, or actually in the context of it, if it's now a positive assessment, do we need to go over in grave detail everything that happened before, or is a summary of the reasons why we're in proceedings sufficient? And in my view, in those situations, it's probably the latter. It's also very important to make sure you acknowledge the issues with your evidence. So do not be overzealous in saying the local authority's plan is completely the right one, there's nothing wrong with it, and why would the court not go with this option? For example, if you're asking the court to make care and placement orders, everybody knows that these are the most severe orders and draconian orders the court could make. It's severing a tie between a child and their birth family, potentially forever, but certainly for all of their childhood. And there's absolutely nothing wrong with acknowledging that within your final evidence. And in fact, it's really important that you do. If you try to minimise these things, it will only make you look unbalanced in your view. And as Aaqib said earlier, balance is really important. You will come across as a much better and more thought through social worker if you can acknowledge that there are parts of your final care plan which aren't perfect, because ultimately there will be no care plan that is perfect and pleases everybody. So it's really important to be acutely aware of recognising the issues and acknowledging them within your evidence, because that also allows you to explain why, despite those problems, this is still the right plan for the child. Adoption is a really severe order, but in lots of cases it's the only one that's right for the child, and it's absolutely fine to say both of those things within the same document. Similarly, in terms of evidence rules, again, it's important not to rely on things which can't be backed up by supporting evidence. You as a social worker on the ground might have a gut feeling about something. You might have a gut feeling, for example, that mum and dad have resumed their relationship. You might have a gut feeling that mum or dad is misusing substances again. But if you don't have any evidence to back this up, and this is just simply a feeling, it's better not to mention it, and it's better not to try and rely on it in your final evidence if there's nothing that will actually back it up, even to infer that what you're saying is correct. Again, it weakens the rest of your argument if you're relying on things that aren't strong evidentially, and that's something that your lawyers will advise you on, and definitely your solicitor, when reading your final evidence, is likely to highlight to you in any event if they think that there's something in there which either shouldn't be mentioned or shouldn't be relied upon. Finally, and probably most importantly, is do not be late with your documents. Sometimes it's unavoidable, things happen, diaries change, there are emergencies, there's sick leave, all of those things come up and they're unavoidable. But if those things happen, it's really important to let your manager know straight away, and also to let your lawyer know straight away, so that if the timetable does need to be varied, it can be done at the point where there's a problem, and not after the assessment deadline is due and the judge is asking where it is. Again, this sets the tone for the judge. If the professionals, and particularly the local authorities, it's our case that we're bringing, are not on time, it doesn't set a great tone for what's in your evidence. And actually, the judge is going to be reading it thinking, this was late, why was it late? Is there anything in here that explains why it was late? Or has the social worker simply not time managed properly? That's very rarely the truth of it, and actually there's always an explanation for why something's late, but it's important that that's brought up early, acknowledged and sorted, rather than being left until after the deadline has passed. Again, if you think about speeding, the speed limits on the road are a deadline. They are a limit, and it's not an aim to see if you can just get there, on the number. It's the same with deadlines for assessments. They need to be on time, not just after or a couple of days after, or a week. It's really important because that has a knock-on for everybody else, and the court tends not to be very happy when things are late.
So in terms of giving evidence, so you may have had time to prepare a written statement, or it may be an urgent hearing, and actually there isn't much by way of documentary evidence. In any event, you'll need to then give oral evidence, which essentially means you coming up to the witness box and telling the judge and answering questions in respect of your application. And predominantly it is the local authority's application, although it might be the parent's application, for example, to have contact in an order. So there are various different reasons as to how and why you may end up giving oral evidence. But all the same, it's important that you reread any documents that you have prepared, but also the wider documents in the case, because it tends to be that any question will be based off documents that have already been prepared. If you have any issues or errors that you've identified in your case, please let your lawyer, so that's your lawyer on the day, ideally let your in-house legal team know beforehand, so they can resolve any potential issues. But if they've not been resolved, then let your lawyer on the day of the hearing know, and so when they take you through your evidence, you can correct whatever mistake there may be in there. And of course, that's usually tends to happen with smaller or minor mistakes. If it's the case that you change your entire care plan overnight, then that's something that will need to be discussed between the advocates and then discussed at court. In terms of issues, of course, your lawyer can't coach you. We can't tell you what questions you'll be asked, and importantly, we can't tell you how you should respond. But if you query, well, what are the issues that the court's going to be interested in? Well, that's a perfectly proper question, and your lawyer can then perhaps take you through the threshold document, which looks at exactly what's being argued and the basis on which that's being argued. Also importantly, but can never be overstated, turn off your mobile phone, please, because as busy social workers, I know that you're always on the go, but it's important that when you're giving evidence, you respect how solemn of an occasion it is, and that the court is also aware that you aren't distracted. And of course, please prepare thoroughly, even if it's a really straightforward application. I had a case, it was a final hearing, which was supposed to take half a day on submissions. Essentially, the care order had been agreed by the mother. The father wasn't involved in that case, but she had agreed to the making of a care order. And the only issue outstanding was the issue of contact. Because proceedings were going to finalise on a care order, there is an ongoing duty for the local authority to promote contact. And that is something that this mother obviously wanted to have increased. During the course of the social workers cross-examination, even though it was a really niche issue, and actually the more contentious issue of a care order being made or not being made was not something that was being looked at by the court, the social worker sadly just did not come across as having prepared for the hearing, was unaware of her own documents, and essentially the court at the end of her evidence said that she had no confidence in the local authority as a whole, so not just the social worker, but the local authority as a whole, that she would even promote contact. And so not only did she endorse the mother's position, this was the judge, endorsed the mother's position that she should have more contact, but what she did was also put that into a contact order. And at the local authority, that is not a place that you want to be, because then you have to provide for contact exactly how it's stipulated in a contact order. And one of the flexibilities of having a care order and being able to review that is then lost, because you no longer have that power available. So even if it's a really straightforward issue, please prepare as you would in any case, and be aware that you do not want to be criticised, because of course the court, by saying that she had no confidence in the local authority, well, that's much broader than just the social worker, but it is the local authority that is the applicant in proceedings, and it's not a good look if you've given a reason for the local authority to be criticised in a judgment. Particularly, I mean, on this occasion it wasn't published, but if there is a published judgment, of course that is more cause for concern. So just be careful when preparing. And in terms of examination in chief, that is when your own lawyer asks you questions. So it usually starts off with, and I'm sure that many of you have given evidence before, but actually quite a large number of social workers don't give evidence because proceedings may have concluded on an agreed basis or are dealt with by submissions. So there's a real range of hierarchy in terms of social workers and how senior they are. I've had very senior social workers not having given evidence before, and then I've also had very junior social workers having given evidence on a number of occasions. So there's no real rule when it comes to having given evidence. But of course, when you do give evidence, you'll be chiefed, and that will mean going through the whole process which any witness would. You'll need to confirm whether you want to be sworn on a holy book, or if you want to take an oath and affirm. That's completely your preference. There's no inference drawn one way or the other. So please don't feel that you have to express your religious persuasion or otherwise when you promise to tell the truth to the court. So what is examination in chief? Well, basically that's you being asked questions by your own lawyer. They can't be leading questions. So for example, I can't ask my social work client to give me a yes or no response. That essentially is funneling them down to giving me a certain response. But they are usually open-ended questions used to update the court on what's happened. And that tends to be important because as the social worker, you may have filed your final evidence weeks or even months ago. And it's really important that the court then has an update with what's happened. Of course, it may be that it's not necessary, but it does depend on exactly what's been happening on the ground. And importantly, your lawyer can't give evidence on your behalf. So even though you may have told your lawyer on the day of exactly what's happened, we can't then stand there and tell the court, because of course that would be giving evidence, and that needs to come from a witness. And in terms of how that process works, so when you are sworn or you give a promise to tell the truth, you'll always be asked for your full name and your address. I always ask social workers to confirm their role in proceeding, which might seem like an obvious question, but sometimes social workers have only recently been involved, and there might be someone else giving evidence with more historical issues, and so it's really important that the court is clear as to exactly how long you have been involved. And of course, you'd also be taken to your statements. I've had a case where there were 7 or 8 different statements that the social worker had prepared, and you have to reference each and every statement before being asked questions by your own lawyer. And I've also already discussed in terms of you might be asked fairly obvious questions that you may have told your own lawyer the answer to, but it's important that the rest of the parties and the court is also made aware of what your updating evidence is. You'll rarely be permitted to repeat existing evidence. So as lawyers, we need to be careful not to go over old ground, because the judge might simply then say, well, actually that's covered in such statement, and that's that, so you won't be able to respond or give further evidence on points which you may have already addressed. And likewise, this process, you can't be coached, so you can't be told what questions will be asked from your own lawyer and what your responses should be, but of course the issues can be explored beforehand.
So cross-examination is something that some of you may or may not be familiar with, again, if you have or haven't given evidence. And cross-examination is something that can really be different every time you do it, or that you're involved in it when you're cross-examined, because it completely depends on who is on the other end of that cross-examination asking the questions. Some are more robust than others. I would like to think I have quite a gentle style in cross-examination. I prefer to kill with kindness, but there are other people who go straight for the jugular, so that's something to be aware of. Cross-examination takes its different forms depending on the advocate. That's not to say that you're being interrogated. Your lawyer and the judge are both there to ensure that that's not the case, and the same rules apply to you as any other witness, that any questions asked cannot be used to intimidate or harass the witness. And so if a lawyer is doing that to a social worker, it applies exactly the same way as if it was done to a parent, and the judge will step in and stop it. So cross-examination really is something not to be fearful of, because it shouldn't be a distressing experience. It's questioning by either the parents' representatives or sometimes the children's guardian's representative in opposition to your case. Sometimes the children's guardian will agree with the local authority's plan. Their advocate is still allowed to cross-examine you as the social worker, but their questions are going to be very different to those that are asked on behalf of the parents, because the children's guardian will want you to say particular things that bolster your case. So the order of evidence is that the person who is representing the person giving evidence will go first. So if you're for the local authority, I would do your evidence in chief first. You would then be cross-examined by mother, father, any other family members, if there are multiple fathers, for example, or grandparents, and then finally by the children's guardian. If within your questions and answers to either any of the parents, you say something which the children's guardian feels needs to be repaired, or you've conceded something that the children's guardian thinks perhaps you've been overly generous about, they will fix that, so to speak, by asking you questions at the end to reiterate the points that they want to make clear on the guardian's behalf. So it's important to be aware of the children's guardian's position, and therefore the tone and context of their cross-examination, and not to treat that as hostile if it's intended to be the opposite. It's important when giving your evidence that you are balanced and fair in the same way that you should be in your written documents. You need to concede the positives, and you don't need to shy away from them. For example, if you are overly negative about somebody, the court will not see that as having been balanced or fair evidence, and you may be in a situation, as Aaqib has described in his example, where the court feels that they don't have the confidence that the social worker can think fairly and balancedly about a parent or a particular issue. For example, if contact is positive, then say so. You can carry on that with a but. Contact is only a snapshot. Contact is not the same as being in the community with a child. It's a controlled environment, but you do need to concede that contact is positive. Don't try to pick through the contact notes and find one tiny minor incident where mum or dad forgot to bring the child a snack, for example. That's not negative contact. It's a mistake which everybody makes. It's much better to concede that contact on the whole is really good, but contact only shows a snapshot of the picture. That's a fair and balanced answer to a reasonable question. Again, some lawyers have different types of styles of cross-examination to others. If somebody cuts you off mid-answer, politely ask to continue. It's very likely the judge will step in anyway and say the social worker wasn't finished, or you allow them to finish their answer. But if the judge doesn't do that, you're perfectly entitled to say, excuse me, I hadn't finished answering, would you mind if I continued? If the judge doesn't want to hear anything further from you, they will say so, but that's very unlikely. Make sure to stay to what's relevant to the answer the question that's being asked of you. Again, the same as in your written documents, don't waffle. The judge will stop you, or the person cross-examining will stop you. Again, that's the same as the example in the written document. If there's background, which everybody is aware of, there's no need in the witness box to begin to repeat it sort of verbatim and say, you know, this is positive, but in 2003, mum did X, Y, and Z. There's no need to go into that level of detail, and very long answers will simply be cut off if they're not to the point of the question that's been asked. It's also important not to simply apply theoretical knowledge without considering the facts of the case. For example, saying that domestic abuse impacts upon children is completely valid, but it needs to be applied to these specific facts in this specific case and these specific children. So if you're asked on behalf of a parent whether you agree that it's right that the children never witnessed any domestic abuse between mum and dad, and that's correct, then you can concede that and say, but we know that domestic abuse impacts upon children in different ways, and in this case it impacted on X because he or she saw mum very upset after there'd been an incident with dad, or they saw dad very upset after an incident with mum. That is applying the theoretical knowledge to the case. The same in respect of sibling decisions. Quite often the sibling relationships are the most enduring of any child's life is trotted out. That's completely right. It's the right theoretical knowledge, but you need to make sure you're applying it to this case. So if you're deciding that the children should be placed together, that's a valid point to make, but you need to back that up with, and these siblings have a really positive relationship with one another, it benefits them to be placed together, and it's important that they stay together because the sibling assessment in this case says X, Y, and Z. So it's important that you bring it back to the facts of these children and these parents. What's not helpful sometimes is when social work professionals quote theoretical knowledge and state that that is simply the answer to the question that they've been asked, because it doesn't make any connection to the specific facts which the court's concerned with. If at any point you're asked a question and you genuinely don't know the answer, just simply say so, the same as if you would to your lawyer. And if it's the case that you know that somebody else can answer that question better, for example, if there's a family support worker involved and you know they're giving evidence, you can say that's a question better put to X or Y because I wasn't present for that incident. Or if you say I genuinely don't know or I can't remember, and I need to take a moment to check my notes, that's also fine. Again, it's really important not to guess. It's obvious when somebody in the witness box panics and says something that they're not 100% sure of, and usually the person cross-examining will pick up on that and ask the question again, ask, are you sure? Ask, do you want to think about that? And the judge will want you to give a fair, balanced and correct answer rather than something that's rushed because you feel on the spot.
So these tips that we have set out in these slides, particularly in respect of cross-examination, they do apply to all witnesses, whether you're a social worker, a parent, a guardian, or any other type of person giving evidence. It's important to note that if you do need some time to refresh your memory or compose yourself, then please ask for a moment. The lawyer who is cross-examining you will most likely then allow you to have a moment to think about your response and then to give your answer. It's always important or preferable to ask for some time to think about a response, then be hurried into something that you then would want to change later, because that makes you look as if you might have changed your mind midway through your evidence. If you do need to refer to your documents, then please do say so, but it is very important that the court is then aware that that is what you wish to do so. So please don't start reading your statement from top to bottom whilst you're giving your evidence. But if you do feel the need to look at it, and then please do say that. Of course, if you have said something during your evidence which you later rely or immediately realize was an error, then of course accept it and simply own that, and that should be that. Now, of course, you've got to remain calm and composed. It is a very nature of cross-examination that you'll be tried that the other side, so the lawyer will try to undermine you, will try to show you that your analysis is flawed or somehow incorrect, but it's important that you are able to remain professional and composed, and above all remain open-minded, but also able to put your opinion and your view across in a really rationalised and thought out manner, because what the court really does need is to understand how, after looking at all of the assessments and all of the evidence, you have reached the conclusion that you have reached, and that's what is going to be persuasive to the court. So there might be a lot of bluster and questioning and very inquisitorial tones adopted by lawyers on the other side, but if you can justify your position, then that is a good place to be. In terms of needing breaks then as a social worker doing your cross-examination, in my experience anyway, courts are less inclined to be receptive to those types of requests, but not because the court won't allow them, but simply because parents usually have had things like ground rules hearing and special measures, which has already made provision for those types of breaks to be put in place. But I had a case recently where one of the social workers had a medical condition which meant that they had to take breaks at any given, well, not any given time, but at regular intervals, and so that was something that was important in that case. And finally, it's really important to remember that even at the end of these proceedings, you as a social worker and your team within Children's Services will most likely need to work with these parents on an ongoing basis. So it's really important that as you give your evidence, you must give it robustly and you must justify yourself, but never in a condescending or dismissive manner, which will then impact upon your ability or your team's ability to work with the parents in the future. Sadly, we know that care proceedings quite often do involve parents who have been involved in previous public law proceedings, and what you don't want to be doing is creating that cycle where trust is forever broken, and parents are then trapped in this constant cycle of public law proceedings and not feeling able to work with professionals. And so the takeaway is always be fair but be robust and be prepared to justify your position at any time.
So that brings us to the end of our presentation today. Thank you very much for giving up your time this afternoon and joining us. Hopefully you feel that you have learned something. We have still got a bit of time, so I'm just going to go back to the first slide where Aaqib and I have our email address. And if anyone does have any questions, then please do feel free to send those across now, and we'll just hang on for a few minutes whilst you send those across and answer anything that you wish to ask.
I have had a few questions in respect of the slides. I'm told that slides will be sent out to everyone that signed up, and also the recording from today's seminar, so hopefully you have something that you can then file away.